Okay, everyone, today we're going to go through an update of new employment laws and legislation that came up last year and is in effect this year. We'll go through that and also a COVID update. My name is Jamie Bossuat. I am a lawyer at Kroloff, and I practice primarily employment law and also business law and litigation. I help my clients with a wide range of issues, from developing policies and giving advice on current employee issues to assisting with claims from employees and representing clients both in administrative hearings and then in lawsuits all the way through trial. What I could do here today is give you basic information about what has changed in the law. We don't have the capacity in this context to give legal advice on a specific issue that you're facing, but hopefully what you'll take away from this presentation today is some of the new updates and issues to look for in your own workplace, and hopefully some action items that you can take back and apply to help you be more compliant and reduce some of your liability in 2021. So we're going to start with COVID-19 and health and safety. That's the first topic. We're going to go through a variety of topics today. It's a lot of material, but we'll try and make it easy to understand. At the end of each section, I will give an opportunity to ask questions. So if you want to ask during the presentation, that's fine, or you could wait until the end of each section as well. I like to start out any discussion about COVID-19 and its regulations and laws with just some basic background information on isolation recommendations. So this is the current isolation recommendation from the CDC. It's also been adopted by the California Department of Public Health. So isolation is for an individual that has tested positive for COVID-19, whereas we refer to quarantine as the period where someone who's been exposed but hasn't actually been diagnosed with the illness, the amount of time that they have to stay home. So for isolation, those precautions can usually be discontinued after 10 days after symptom onset with a resolution of fever, without fever reducing medications for at least 24 hours, and with improvement of other symptoms. This can be extended for up to 20 days, depending upon the course of illness. So for a very severe illness, it would not be unusual for your employee to come with a doctor's note putting them out for up to 20 days after illness. The quarantine recommendation is 14 days, but as we go forward in the next slides, you'll see that that is reduced to 10 days and then to 7 days for some critical infrastructure employees and healthcare workers. And anyone who has recovered from COVID-19 in the last 3 months and does not have symptoms does not need to re-isolate at this point in time. There are some strategies for discontinuing isolation earlier, which can be used, and we'll see that on the next slide. Also, retesting is not recommended at this point in time, and we'll go through that. You can actually request a negative test for someone to return back to work and why that is. So this is the website down there on the bottom. This is the California Department of Public Health letter that was issued on December 14th. I just plopped a screenshot of it there on the slide for you. This indicates, in line with the CDC recommendation, that anyone with a close contact, being defined as within 6 feet for 15 minutes or more over a 24-hour period, and it doesn't need to be consecutive, it could be 3 instances of a 5-minute interaction, can discontinue quarantine after day 10 from the last exposure without any testing. That can be shortened to discontinuing quarantine after day 7 if a negative result, test result was received after day 5. And this would apply to asymptomatic healthcare workers or emergency response personnel and others. And that pertains to staffing shortages. And Asymptomatic contacts permitted to reduce quarantine less than 14 days have to comply with some additional requirements, which are listed here, which would be maintaining a 6-foot distance from others, using a face mask at all times, a surgical face mask, self-monitoring for symptoms to make sure that they don't develop symptoms that would then trigger an isolation period, where we were talking about that on the last slide. And this is also from that document. I pulled this out because it's unique to healthcare workers and critical infrastructure workers. There are additional guidelines on the California Department of Public Health website and the CDC website pertaining to these workers, but they can discontinue self-quarantine after 7 days with testing, and this just clarifies that. So if you are faced with this kind of issue, go ahead and check that website that's down at the bottom. And also check the California Department of Public Health website generally to see if this recommendation changes, because it has changed pretty frequently over time. It's been pretty stable since December, but if you're encountering an issue, always check the websites at that time to make sure that they haven't changed since you watched this presentation. In line with COVID, issues, often comes up the need for an illness and injury prevention plan. An illness and injury prevention plan is a requirement in California for any business with employees. And that has to be in writing and in place and available to employees. And employees have to be trained on it in a couple instances: when a new or previously unrecognized hazard is identified, and to allow supervisors to familiarize themselves with those hazards. So COVID is considered by Cal OSHA to be a new and previously unrecognized hazard, and that triggered an obligation to update IIPPs. And in the early stages of last year, we saw them as COVID safety plans. The verbiage has changed throughout the year, but you do need to have a plan in place to address the spread of COVID in your workplace, and also generally an illness and injury prevention plan in your workplace if you don't have one. So this slide lists the websites where you can find information to create an IIPP for your workplace. They have templates up on the Cal OSHA, well, actually this is the Department of Industrial Relations website. And also they have released a model COVID-19 prevention plan, a CPP, that's what they're now calling them, very similar to the plans we were putting in place last year and calling them COVID supplements or COVID safety plans. And so this all needs to be put together, distributed to your employees, and your employees need to be trained on it along with their supervisors. So if there was an outbreak in your workplace, for example, and you get a Cal OSHA inspector out, this is what they are going to want to see and what will protect you if it's done correctly and thorough enough from a citation. So moving into some of the new laws that we saw during this legislative session of 2020, there was a lot of regulation pertaining to notice that has to be provided to employees who may have been exposed to COVID in the workplace. So employers have to provide written notice to all employees and employers of subcontracted employees who were at the work site within the infectious period who may have been exposed. And what that is considered to be is what we mentioned earlier, within 6 feet of an infected individual for 15 minutes or more over a 24-hour period during the infectious period, which is the 48-hour period before the onset of symptoms or before a positive test result. So if you have an employee that comes to you and says, you know, I developed a cough this morning, I can't come into work, I'm getting a COVID test, and they go and get that COVID test and get the results in 2 days. The infectious period is the 48 hours before they developed the cough. Or if they didn't have symptoms and just happened to go get a COVID test at one of our local testing sites and they test positive and they're asymptomatic, it's the 48 hours before the positive test result. Written notice of the exposure has to be provided to all employee representatives, including unions. The notice has to include a list of the COVID-related benefits that the employee may receive, which would include potentially workers' compensation benefits, any COVID leave, any paid sick leave, and also a copy of the company's anti-discrimination, anti-harassment, and anti-retaliation policies. And the company also has to provide notice regarding disinfection protocols and a safety plan to eliminate any further exposures. Now, if you have a COVID-19 safety plan that you prepared, or a COVID prevention plan that covers these topics, that can be included as an attachment to whatever notice you're distributing. And these all have to be provided within 1 business day of you learning of a positive confirmed case of COVID. And that is a pretty quick turnaround. So my recommendation has been, and is still, go ahead and get these prepared in advance. We're going to continue to see COVID cases developing in the workplace. Now that these rules have been in place for a while, there's a lot less leniency toward employers that aren't giving appropriate notices. And it creates an employee relations problem when notice isn't given promptly as well. We saw a lot of that in the fall in the news. Most of the employees that were upset that they weren't properly notified quickly enough. You have to notify those that were exposed, and we talked about the definition of that. A lot of employers are also giving notice to all employees, which wouldn't be required, but it's sometimes helpful from an employee relations standpoint, just to say we did have an exposure in our workplace. Of course, you have to protect the privacy of the employee who is the source of the exposure. We don't have any reason to believe you were exposed. We want to remind you of all the steps we're taking to protect you. That kind of thing can go a long way. The notice can be provided by email or text if it's reasonably anticipated to be received by the employee within 1 business day. And the notice should be in English or in the language understood by the majority of the employees. Cal OSHA issued some emergency rules last year. They require that employers notify local public health agencies within 48 hours of a sufficient number of COVID-19 cases to constitute an outbreak. I have the link there to the definition and reporting guidance. The emergency rules also removed or shortened the notice period that OSHA had to comply with before issuing a serious citation. So this limits the ability of employers to provide information to fend off a serious citation. And so the recommendation for you, if you're faced with an outbreak or a significant number of cases in your workplace, or even just one, or an OSHA inspector at your workplace, is to consult counsel if you have any question about those notices, and then consult counsel with regard to that OSHA inspection, because it's helpful to get as much information beneficial to the employer to the OSHA inspector earlier than we used to think, because that period has been shortened. Cal OSHA then issued a temporary COVID-19 standard. You can see this has very much evolved throughout the year. This became effective November 30th of last year. It defines an outbreak as 3 or more cases in a 14-day period, and a serious outbreak as 20 or more cases within a 30-day period. It requires employers to offer and pay for COVID testing during work hours for those who were exposed at work. It requires employers to exclude exposed employees for 14 days, and this was subsequently modified to 10 in compliance with the CDC standard. It requires employers to follow protocols set forth by the Department of Public Health for returning employees who've had a positive test to the workplace, meaning they have to meet those criteria we discussed to end isolation. And employers cannot require a negative COVID test as a condition of returning to work. And this is because many employees, from what I understand, continue to test positive, even though they're no longer contagious and they meet the criteria to end isolation. So requiring a negative COVID test would exclude more people from the workplace than necessary. I mentioned on the previous slide that the 14-day period was reduced to 10. That was done by executive order of the governor and reduced that. There's a link there to that information. And so now that brings the emergency rules from Cal OSHA into line with the current recommendations of the CDC and the California Department of Public Health. There's a lot of talk right now about COVID-19 vaccines and whether employers can require them or incentivize employees to receive them. COVID-19 vaccines can be required. However, there are some limitations on that. They have to be related to a business necessity. The failure to be vaccinated has to pose a significant risk of substantial harm. And this has to be based on reliable, objective information to support the concern of the employer. The Americans with Disabilities Act, the ADA, and Title VII, which is our federal anti-discrimination in employment law, require that employers accommodate an employee with a disability or with a religious objection to a vaccine. I mean, a disability that prevents them from receiving the vaccine, or an employee who has a religious objection to the vaccine. So that needs to be taken into consideration as well. There has been some discussion about the emergency status of the approval for these vaccines. I think common wisdom at this point in time is that that emergency status would prevent the government from mandating vaccines, but not a private employer. In certain instances, employers can exclude employees from the workplace, and this is the standard that applies when an employee, for example, is not vaccinated, and that is a requirement of your workplace. So one of the standards is that you can exclude employees from your workplace if they're not vaccinated, if failure to vaccinate is a direct threat. This has to be individually assessed. And so you would look at that particular employee, their particular work situation, whether they're around others, if they're telecommuting. I think it's going to be hard to establish that not being vaccinated is a direct threat to anyone else. But we look at these factors when evaluating a direct threat: the duration of the risk, the nature and severity of potential harm, the likelihood that harm will occur, the imminence of potential harm, and whether the harm can be eliminated through an accommodation. So for example, if you have an employee who has a serious health condition that would cause their doctor to recommend they not receive a vaccination, if they can telework, then they're not a direct threat at that point in time. And so what this does is this kind of balancing test with these factors helps you to evaluate whether your workplace is a type of workplace where you could require a vaccine. Obviously, with healthcare workplaces, for example, the risk is much greater than in an office environment where there's very little contact with the public or other employees even. So this is something that has to be evaluated on a case-by-case basis. The other basis for excluding an employee from the workplace is if the vaccine is a safety qualification of the job. This is typically a standard that's applied in jobs that protect public safety. For example, a police officer who is working on the street needs to be able to run and defend himself and others. It has to be supported through objective facts about the job. And it has to be consistent with business necessity. So there has to be a real reason that having the vaccine is a safety qualification. One caution when requiring vaccines or offering them through your workplace is that you do not obtain prohibited disability-related information about your employees. There are privacy laws that protect an employee's right to medical information and also information about a potential disability. And it's important not to collect that information when unnecessary. So of course, any medical information received has to be kept confidential. Employees should be specifically instructed not to provide any genetic information, such as a family's medical history. And employers who are self-administering the vaccine, I think, are at the most risk for soliciting information that may violate ADA standards. And so one option, if you're going to offer the vaccine to your employees, is to use a third party to do that. So when the third party is collecting information about health conditions that may create an adverse risk for the vaccine, they keep that information, you don't have it, and then you're protected from these disability related inquiries that may be impermissible. And if you are asking just the question of whether an employee has received the vaccine, that would be permissible, but asking why might get you into trouble. I think a lot of the common guidance on vaccines at this point is to educate your employees. There's, as there was with COVID initially, there is a ton of misinformation out there about vaccines. Employees receive their information from all different sources. So to the extent you can provide your employees with accurate and verified information about vaccine safety and the risks of vaccines and the benefits of vaccines, that I've seen does go a long way to convincing more employees to take the vaccine just voluntarily. If you're going to, also you can give employees time off to take the vaccine. You can pay for it. You can arrange a clinic at the workplace so that, I don't think this is available as of yet, but as time goes on, it may be, so that they could get the vaccine. Different things like this may be optional. Assisting them in finding locations where they can obtain the vaccine. All of those kind of assistance doesn't violate any rules and is very helpful. We do have to be careful when mandating vaccines or incentivizing vaccines, that program that you've put in place does not violate wellness program rules. So there are rules governing employer wellness programs that require them to be voluntary, and the higher the incentive, the less voluntary the government considers that to be. So for example, it's clear that giving out a water bottle for employees to get a flu shot is a very low incentive that doesn't make the vaccine program impermissible. But giving a monetary compensation for receiving the flu shot or the COVID vaccine may, because employees are then compelled to do it rather than it truly being voluntary. And we also have to remember that if employees have a religious objection to the vaccine or a reason not to be vaccinated due to a disability, if there is an incentive program that you've put in place, you want to make sure that that employee has an opportunity to earn the incentive without getting the vaccine. So for example, this could be watching a safety video in addition to earn that incentive rather than getting the vaccine. One good comparator for this is if you've offered flu shots in the past, or if you have required flu shots in the past, many healthcare providers do, that's a good guideline to look at in terms of what you could do with the COVID vaccine as well. So I do recommend, if you have an intention of incentivizing or mandating vaccines, that is a good idea to consult with counsel just to make sure that you don't have any unintended legal liability arising from it. So that is the end of my section on COVID-19, health and safety, and vaccines. Does anyone have any questions about any of that material we've covered? No? Okay, we're going to move on then to leaves of absence. This changed a lot this year. So we had initially, beginning April 1st, the rollout of the Families First Coronavirus Relief Act, the FFCRA. That was a federal law that applied to all employers with less than 500 employees. California then passed an equivalent in the form of AB 1867, which applied to employers with more than 500 employees, and also eliminated some of the exemptions for healthcare providers. Both of these laws technically expired on December 31st, of last year. However, the FFCRA leave, the federal leave, was extended on an optional basis through March 31st of this year. So the extension was part of the Consolidated Appropriations Act, and that extended the opportunity to receive tax credits if employers voluntarily elected to continue providing FFCRA sick leave and a family medical leave. And so the way this applies is that if you have an employee who didn't use up the full entitlement that they received in 2020, you can allow them to continue applying that into 2021 through March 31st. So if I spent only 40 hours out of my 80 hours of allotted sick leave under the COVID law, I can use the rest of the 40 through March 31st, and my employer could still receive a tax credit for that. But that is at the election of the employer. It is not required at this point in time. If someone used up their full amount of COVID leave in 2020, they aren't entitled to any additional leave in 2021 under the FFCRA, and their employer is not entitled to any further tax credit. So I just want to go over briefly what the FFCRA provides, which is emergency paid sick leave up to 2 weeks or 80 hours for an employee who's quarantined or experiencing COVID-19 symptoms. That's at a regular pay rate up to $511 per day. If the employee is unable to work because they're caring for someone who's in quarantine or whose school or daycare is closed, that's paid at a lesser rate, 2/3 up to $200 per day. So this emergency paid sick leave portion of the law provides up to 80 hours of paid leave at 2 different rates, depending on the reason it's taken. There's a second component of the law that provided expanded family and medical leave. It's an expansion of the FMLA. So it works in conjunction with the FMLA, and it provides up to 12 weeks, the first 2 of which are unpaid, for an employee who's unable to work because they have to care for a child whose school or child care provider is closed due to COVID-19. This is paid at the 2/3 rate. The employee has to have worked for 30 days or more, and these 2 can be overlapped. So an employee, for example, could use 2 weeks of emergency paid sick leave overlapped with the first 2 unpaid weeks of expanded family and medical leave and receive a total of 12 weeks of pay. There is not the ability to receive 14 weeks of pay, but there is the ability to take 14 weeks off if the employee, for example, used the first 2 weeks of pay for their own condition, and then they took 12 weeks off for the child's school being closed. So distance learning, at this point in time, we've received clarification, is considered to be a school closure. So if your employee is unable to work because their child's school is only distance learning, then that would qualify for this. The days, some of our schools have gone back to a hybrid approach where it's 3 days distance learning, 2 days in person. The employee could not take this leave for the 2 days that are in person because the school is not technically closed during those days. And this would not apply to a regular school break, like spring break, summer break, where the kids are ordinarily out of school and the employees have to find care for them on a usual basis. However, a lot of daycares are closed, or a lot of camps or other programs that used to be utilized for care for children during breaks are not available. So that may trigger application of this. It's also important to note that there are quite a few cities who have implemented paid sick leave laws. Long Beach, Los Angeles, San Mateo, San Jose, Sacramento, and San Francisco. Most have a 500 or more requirement, but not all. And this has been expanding. So if you have employees working in other cities, it's a good idea to stay on top of that and make sure that there is no paid sick leave requirement where they are working. So I just got a question. I work for a company with more than 500 employees. Do we have to pay them for childcare reasons due to COVID? So the that would have fallen under the California equivalent to the law, which did expire at the end of December and has not been extended. So if an employee earlier in the year began the leave before December 31st, the position of the Department of Labor Standards Enforcement was that they could continue it until the allotment ran out. But we've run past that period now into mid-February. So for the most part, there is no obligation to provide leave under the California paid COVID sick leave law at this point in time. There may be other reasons to provide that leave, however, which we will go through in a little bit more detail also. And this slide is one of them. California has a law that requires employers with 25 or more employees to provide up to 40 hours of leave per calendar year for school-related emergencies, including a school closure. So this may apply to some employees. And you can require the employee to use vacation and PTO benefits, but this is a job-protected leave. You can't require them to use sick leave, but they can elect to do so if they would like. Also, employees who are required to stay home with their kids aren't able to work, but they need some wage replacement benefits. Maybe you're willing to give them an extended leave of absence that's unpaid. I've listed here the various benefits that are available. If they're out for their own health condition, they would be potentially eligible for disability insurance if they were able to get a medical note for that. Paid family leave covers the care of family members. You also usually need a medical note for that. Unemployment insurance would cover any job hours reduction or a lost job, and even applies during a temporary job loss like a furlough. Pandemic unemployment assistance is the unemployment insurance program that was put in place for independent contractors and small business owners who aren't employees. California paid sick leave would apply to a quarantine or preventative care. There is a supplemental paid sick leave program for food service workers in California for employers with 500 or more. We went through the FFCRA provisions that expired but can be extended at the option of the employer through March. There are the local government sick leave programs, and then there's workers' compensation. In California, we have a presumption that a worker has contracted COVID in the workplace. If that's not true, if you have evidence that the employee contracted COVID outside of the workplace, the good idea to contact your workers' comp carrier with that information in the event they want to contest the claim for benefits. There's an obligation to report all COVID cases to your workers' comp carrier at this point in time. And if someone did contract COVID-19 in the workplace, they would be entitled to workers' compensation benefits for that. I think this was one of the biggest changes this year was the California Family Rights Act expansion. That is referred to commonly as the CFRA. It provides 12 weeks of unpaid leave for an employee's serious health condition or the serious health condition of a family member. And so here's the basis for the leave: an illness, injury, impairment, or physical or mental condition that involves inpatient care in a hospital, hospice, or residential medical care facility, or continuing treatment by a healthcare provider. This excludes pregnancy or childbirth-related conditions because those are covered by the pregnancy disability law in California. It also covers the serious health condition of a family member where your employee is necessary to take care of them. It covers what we commonly refer to as baby bonding, which is time taken off after the birth or foster care placement of a child or adoption. It covers qualifying exigencies related to active duty in the armed forces. And there's also some provisions for care for service members who are injured. The CFRA used to apply to employers with 50 or more employees. It now applies to all employers with 5 or more employees. So this is a very significant expansion, and it takes the law from employers that often had a human resources professional who are assisting with these kind of leave benefits to small employers with a much more limited capacity to follow the complicated requirements of this law. It also used to require that employees had to work within 75 miles of a work site with 50 or more employees, and that's been removed. So it's just 5 or more. It expanded the type of family members for which an employee could take leave. So now it includes siblings, grandparents, grandchildren, and domestic partners, in addition to spouses, children, and parents. There used to be an ability to require 2 parents working for the same employer to take only a total of 12 weeks of leave. Now they can each take 12 weeks. It added the qualifying military exigency provisions. And then there used to be a provision for those earning the top 10 earners to not be guaranteed reinstatement, and that has been removed. So what this means is that almost every employee handbook has to be updated at this point in time because the definitions and the requirements have changed. So even for employers with 50 or more, their handbook does need to be revised to reflect the changes to this policy. And for those of you who now fall within the law who didn't before, this really should be added to your employee handbook, and you should come up to speed on how to implement it in your workplace because it does have very specific requirements. And we're going to go through a few of them. I could give a whole presentation on CFRA and how to implement it, but we're just going to cover some of the basics here so that you're aware of kind of the outlines of this law. So employees are not automatically eligible. They have to meet some specific requirements. They have to have been employed for at least 12 months as of the start date of the leave. And that's not consecutive. It's 12 months over the past 7 years. They have to have worked at least 1,250 hours in the 12-month period preceding the commencement of the leave. And there's an exception for pregnancy. When we're counting how long someone has been working prior to a pregnancy, we start at the beginning of their pregnancy disability leave rather than the beginning of their baby bonding leave to give them essentially credit for that period of time. So this is just an example of why it's very important to track how these leaves of absence work. There are also very specific documentation requirements about when you have to give a notice to an employee, when you have to advise them whether they're eligible or not eligible. And what that is important for is making sure that you don't inadvertently have to give this leave at a later date. So for example, this employee on this little chart had COVID and was seriously ill. And they took 2 weeks of FFCRA leave on that black bar there for their COVID-related illness. Because it was a serious illness requiring significant medical treatment and perhaps inpatient hospital care, the employer gave them a notice saying, we're also counting this towards your CFRA allotment. So they used up 2 weeks of their CFRA allotment, and that now counts against them because the notice was provided. Then this employee becomes pregnant and they are taken off work for a standard 8-week period, 2 weeks before the birth and 6 weeks after. So that is pregnancy disability leave. So you would give them a notice about that, all of the required documentation. PDL applies to employers with 5 or more. Then this employee wants to take baby bonding. So they have technically 10 weeks left of CFRA leave that they could apply to the baby bonding. Now, if no notice had been given for that first 2 weeks when they had COVID, they could make an argument potentially that they were entitled to 12 weeks because they relied on the fact that they hadn't used up any CFRA leave yet. That's why it's important to give out these notices. And so here we give the employee a notice that they have 10 weeks left and they're expected to return to work at the end of those 10 weeks. It's never a good idea just to automatically terminate someone at the end of these leaves. There are a lot of different factors that go into it, including whether they have a disability, and that needs to be reasonably accommodated. This is a highly litigated area, and there's a lot of risk relating to it, and it's very technical. So this is one area where I would recommend consulting with counsel before terminating an employee who has taken these types of leaves. Also, there are some presumptions that the termination was due to the fact that the employee took the leaves and exercised their rights to the leaves. So that's also something to consider when you're terminating an employee and how much risk exists in that termination. That is my section on leaves of absence. Are there any questions on that section at this point in time? No. Okay. Moving forward then, independent contractors. So just a brief summary of the law as it existed last year, which was the ABC test, which was codified by the legislature following the Dynamex case, for those of you that are familiar with the kind of evolution of this. Basically, that made the law in California that for an independent contractor to be properly classified as an independent contractor and not an employee, they had to meet these three tests. A, they had to be free from the control and direction of the hiring entity in connection with the performance of the work. B, they had to perform work that was outside the usual course of the hiring entity's business. And C, they have to be customarily engaged in an independently established trade, occupation, or business. So a very clear example of this is someone that hires a bookkeeper to come in and assist with bookkeeping functions on a monthly basis. That bookkeeper advertises, she has a website, she does this work for 10 businesses in the area. She's clearly running an independent business. She's clearly providing work outside the usual course of business. It's a law firm, a manufacturing company, not an accounting firm. And she comes in, does her work pretty independently, gives the work product over. It has to be good work product, but no one cares what software she uses in particular, when she does this work, how she does it. What is important is the final work product. So that's your pretty clear independent contractor that would meet all of these tests. In the original AB5 law that made those three tests, the law in California now, there were 7 exemptions and exceptions. So what this means under AB5 is not that these people in these 7 exemptions are automatically independent contractors. It means that they don't have to meet the ABC test. They don't have to meet those 3 criteria. Instead, they have to meet the balancing test that we had in place in California for many years, which is a list of factors. We call it the Borrello test or the common law test that goes through, does the person provide their own tools? How much control is exerted over them? Do they set their own hours? Can they use their own employees to increase productivity? All of these different factors that we were used to talking about with independent contractors. When they're exempt from AB5, they still have to meet those criteria. I think there is a misperception amongst a lot of small businesses that as long as they're exempt from AB5, they're automatically okay to be an independent contractor, but that is not the case. So there are specified occupations, professional services, real estate and repossession businesses, business service providers, construction industry, particularly subcontractors, referral agencies, and motor clubs, which are the AAA tow truck drivers. We had quite a bit of legislation that added additional exemptions or expanded these exemptions this year. So for example, there was a business to business exemption in place previously, which required that a business person be conducting their own business, that they have a written contract in place, that they had their own place of business, but then that created an exemption from all 3 elements of the ABC test. This has been extended to public agencies at this point in time. There is now an exemption specifically for single engagement business to business relationships. So this involves providing services at a single engagement event, like a party or a fundraiser, something like that. Also applying to a series of events taking place in the same location no more than once per week. There is also an expansion of the referral agency exemption. This now expands to consulting, youth sports coaching, caddying, wedding or event planning, interpreting services, and event vendors. The professional services exemption expanded, and it now includes more types of professionals, including content contributors, advisors, producers, narrators, and cartographers. Those who are hired to teach a class for no more than a week. Appraisers, registered professional foresters, and home inspectors. There were some restrictions on the journalism industry that have been reduced. Also, a lot of new exemptions for those in the music industry and performance industries. So musicians and vocalists who don't receive royalties, songwriters, composers, musicians in musical groups engaged for a single engagement live performance, and comedians, the list goes on, it's here for you on this slide. Additional exemptions, this is my last slide on this, I believe, is manufactured housing salespersons, individuals engaged by international exchange visitor programs, amateur umpires and referees, and competition judges. So those, the takeaway from this in terms of what you should be doing for your business to protect you from a claim of an independent contractor is I recommend pulling your 1099s from last year and looking at who was it you actually paid as an independent contractor. Do they meet the ABC test? If not, then you look into, is there an exemption for them? The exemptions are all over the map. They don't make a whole lot of sense other than maybe who had good lobbyists. So it is a little bit tricky to figure out who might qualify for an exemption. Then you have to go through the process of determining whether or not they meet the common law test for being an independent contractor. You want to look at your contracts and see if those are valid and sufficient for some of these exemptions under the ABC test as well. So that's all something that you can get help from counsel if you're concerned about it. There was a case in January of this year that made Dynamex retroactive. This means that currently the ABC test applies to all independent contractor misclassification claims arising from the wage orders prior to 2020. Borrello applies to non-wage order misclassification claims arising prior to 2020, and the ABC test applies to all claims arising after January 1st of 2020. So this matters more for those of us who are litigating or arguing these types of cases. At this point in time, what employers need to worry about is who they're paying as an independent contractor and whether they're meeting the current tests. That's all I have on independent contractors. If there are no questions on that, I will go ahead and move on to wage and hour. So I always like to mention that the minimum wage goes up every year in California. So right now, the minimum wage is $14 an hour for employers with 26 or more employees and $13 per hour for those with 25 or less. This does impact some other things, such as the salary minimum for your exempt employees. I've got the limits here for commissioned salespersons, computer software employees, and the executive, administrative, and professional employees. There are cities across California that also increase their minimum wage. So if you operate in one of those cities, it's a good idea to check out that city's website and see what the current minimum wage is and if you need to increase your pay in that city. Also, this does adjust room and board requirements and what can be deducted from the minimum wage in that regard. That's kind of a funny font there. This case, Flecken versus Apple Inc. Is a case about Apple employees who are required to go through exit searches when leaving the workplace. They had to flag down they had to clock out, flag down a security guard, and then wait in line until they could be searched. And the court said that that was compensable time, in part because these employees had to go through this exit search if they brought in a bag or an iPhone. And Apple employees always bring iPhones. So this wasn't really a voluntary activity. So the court said this is compensable. They should have been paid for those minutes. What Apple could have done to fix this would have been to have the employees clock out after the exit search. We had some good cases on meal and rest periods, but I think what's important is to make sure that your employee handbooks, if you're updating it for CFRA, make sure that that employee handbook is updated to have current meal and rest period law in there. You wouldn't want to have a policy that is invalid because it is old. This has evolved over the last 5 to 10 years. And so what's important is that your employees are receiving rest breaks for every 4 hours or major fraction thereof, and that they're receiving meal periods of at least 30 minutes. Even if that's an on-duty meal period, that still needs to be 30 minutes. And it has to be taken within the appropriate time frame, which is before the end of the 5th hour of work. Travel time may be compensable, depending on whether an employee carries tools in their vehicle and how much control is exerted over them during that time period. If they aren't allowed to stop for a soda because of the value of the tools in the car, for example, that would make that time potentially compensable. So if this applies to you, this is something to look into this year. There was a case on unlimited vacation time last year, which applies to those of you who usually have executive level employees or salary exempt employees that are allowed to take as much time off as they want on a flexible schedule type of basis. So as long as they're getting their work done, you don't count against them for sick time or potentially also PTO or vacation. They just have more flexibility in how they allocate their work. And those policies have to be in writing. In this case, the employer ran into an issue because they had a handbook that applied to non-exempt employees, but no written policy pertaining to their exempt employees. So this employee's employment ended and she wanted to be paid out vacation. And the court said because they did not have a compliant unlimited time off policy, she was owed some compensation for that. So if you have an unlimited time off policy for some or all of your employees, you want to make sure that that's compliant. Reporting time pay is another wage and hour issue that's been coming up a lot. And this relates to how much control you're exerting over your employees during a call-in period. If you're not compensating them for an on-call shift and they are required to report to work if they get a call, some of that time is compensable because the employees can't travel out of town. They have to have already arranged child care, et cetera. So that time is not really their own if it's a mandatory show up to work if you're called in. So that's something that you need to consider if that applies to your workplace, and make sure that your current policy is compliant based on this case, Herrera versus Zoomies. If you have 100 or more employees this year, you have to submit a paid data report by March 31st to the Department of Fair Employment and Housing. They did come out with a form to do that a few weeks ago, so just be aware of that if that does apply to you. Okay, that's all I have for wage and hour. I think the major takeaway here is we've seen a trend in wage and hour cases for trying to capture every single minute that an employee works or performs any benefit for the employer. So if they are required to clock out and then perform any work, whether that's waiting in line for a security check or setting an alarm, helping other people to leave the building, anything like that is potentially compensable. So you want to make sure that your timekeeping systems are capturing all of the time that the employee is subject to your control. You know, it's never a bad idea if you have complicated pay practices, bonuses, overtime, especially bonuses. If you have clock in and clock out procedures, it's never a bad idea to audit those. Our firm does those kind of audits and can give you an idea of areas of potential liability, or to do an internal audit and look at what type of time are your employees submitting? Are they getting their meal breaks? Are they getting their rest breaks? Are they all compliant? Because really in California, it's now coming down to the minutes, and whether every single minute is compensated and whether a meal period was taken 1 minute late. So it's all becoming very important. And if you have a lot of employees, that's a good way to reduce your liability exposure. Okay, moving into human resources and workplace policies. Employee settlement agreements were limited last year. They can no longer include no rehire provisions unless there are specific criteria met. One of those is that the employee engaged in sexual harassment or other criminal conduct. The important takeaway from this is that if you have suspicions that there is misconduct of an employee, it's important to begin and conclude that investigation promptly so that you can properly include a no rehire provision in a settlement agreement with that employee. Also, for those of you who employ minors, your human resources employees are now mandatory child abuse reporters and need to be trained on those obligations. Harassment, discrimination, and retaliation. There aren't too many updates in this area this year. Harassment training became mandatory for employers with 5 or more employees last year, and that had to be completed by January 1st of this year. If you haven't done that, I do recommend still going ahead and doing it. It's a 2-hour training for supervisors and a 1-hour training for non-supervisors, and that has to be conducted within 6 months of hire or within 6 months of promotion, and then every 2 years thereafter. There are programs online to do this. I offer these trainings as well. So if you have not done this, it's a good opportunity at the beginning of this year to go ahead and get this done for your workers. The California is constantly expanding the amount of time for filing administrative complaints and lawsuits. That trend continues this year. This is a federal court case pertaining to after acquired evidence. I think the takeaway from this case is to do background checks and to make sure that your employees have all of the requirements for their job, so that you could not end up in a situation where an employee is not actually qualified for their job. In this case, the defense used that as a way to defeat the claim. Okay, the last section I have here is the Consumer Privacy Act. The Consumer Privacy Act, we did a webinar on it, which will be going up on our website. We did that in January. It applies to businesses who have 50,000, who collect information on 50,000 or more residents. That could be as simple as an IP address if you have a website that sells product and goes through a lot of information. For convenience stores even, they hit this number relatively quickly, depending on the number of transactions occurring in their business each day. So if you are covered by the CCPA, what you want to do from an employment standpoint is make sure that you provide a disclosure to your applicants and employees about the type of information you're collecting from them and what it's being used for. We did some updates to these for clients last year when employers started collecting information on temperatures, exposure to COVID, et cetera, because that's all personal information. And then you have to apply adequate security measures to the data you're collecting on the employees. And if you want to know more about whether you are subject to the California Consumer Privacy Act or what it entails for your consumers rather than just your employees, go ahead and check out that webinar on our website. That goes through a lot of those basic details about what a business owner should know about it. And that is the end. I made it in an hour. I know there's a lot of information, but hopefully it gives you some ideas of what to look into to reduce your liability this year and what things are new or are really important and changing. So if you have any questions, you can go ahead and submit those in the chat or the Q&A box. And if not, if you would like to receive a copy of the PowerPoint slides, feel free to go ahead and send me an email and I will get those out to you. Or if you have any questions, you're welcome to reach out to me by email or phone after the presentation as well. All right. Well, thank you for attending. And I'm not seeing any questions. So I'll go ahead and end the meeting and the recording. And so if you want to reach out to me, feel free to do so. Good luck this year in applying all of these changes and dealing with everything we're facing as business owners. So thank you and good luck.